What does it take to win a professional negligence case without expert evidence? I was defending a professional, let's call her a specialist in her field, who had been sued for negligence. The plaintiff's claim boiled down to an allegation that my client's professional services had fallen short of the standard of care. Normally, this is a complicated question to sort out, because professional negligence cases are almost always decided based on expert testimony to establish what a reasonable professional would have done in the same circumstances. The courts rely on expert evidence to explain the standards and intricacies to a fact finder. Without that expert testimony, a plaintiff is typically left adrift, unable to anchor their claims in any authoritative point of reference. In this particular case, the plaintiff had made bold claims, but had never managed to produce a qualified expert to validate them. From the defendant's side of the aisle, that omission was glaring and potentially fatal to the plaintiff's case. My task was to bring a motion to dismiss on the grounds that, with no expert evidence, the plaintiff simply could not meet the burden of proving negligence. When the day of the motion arrived, I took my seat in the courtroom, conscious of the many unknown variables, one of them being the judge. I had not appeared before this judge before and knew little about his jurisprudential preferences. Judges can vary significantly in how they approach cases. Some are keenly analytical, some lean on precedent, others are more comfortable with the practical realities and subtle signals provided by counsel. Not knowing which type I was facing, I prepared thoroughly, making sure my submissions were organized and clear. My opposing counsel sat a short distance away, also waiting, no doubt hoping for a miracle to keep the plaintiff's case alive. Before our matter was called, the judge decided to address another upcoming case scheduled to follow ours, a short trial also dealing with professional negligence. Apparently, the plaintiffs in that subsequent case had similarly failed to secure expert support. The judge, who had not yet familiarized himself with the specifics of my motion, took a few minutes to speak to the parties in that other matter. He explained in detail his experience and understanding of professional negligence law. He mentioned that he himself had practiced in that area for many years before taking the bench. In that prior life, he had developed a keen appreciation of what it takes to prove professional negligence. He spoke authoritatively, not merely repeating textbook rules, but conveying genuine practical wisdom. What came out of his mouth next made my ears perk up. The judge stated, "I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence." The clarity of that statement was breathtaking. It was as if fate had arranged a perfect lead-in to my motion. He had not read our motion materials yet, had not weighed in on the specifics of my case, but he had just delivered an impromptu legal seminar on precisely why plaintiffs need expert testimony to succeed in a professional negligence suit. When our matter was finally called, I almost felt a mischievous smile tugging at the corners of my mouth. Here I was, ready to argue a motion to dismiss a case on the exact grounds the judge had just explained were indispensable for the plaintiff's success. I rose, introduced myself, stated the nature of the motion, and then, with great satisfaction, reminded the judge of his own words. "Your Honor," I said, "as you just indicated in the matter that follows, professional negligence claims hinge on expert evidence. My client stands accused of professional negligence, yet the plaintiff here has presented no expert report, no qualified opinion, nothing to ground their claims in a recognized professional standard. As you just explained, success in such a case would be, well, impossible. I am asking this court to dismiss the matter on that very basis." The timing and synergy could not have been better. I could see the recognition cross the judge's face as he realized how perfectly his impromptu lecture dovetailed with the legal argument I was making. This was not about cheap theatrics. It was about the core principles of professional negligence. Without someone with the right credentials to say, "This professional failed to meet the standard," the plaintiff's case was little more than an unsupported narrative. Courts require something more substantial, an expert's voice, grounded in the rigors of the profession, that can establish what a reasonable professional would have done under similar circumstances. Opposing counsel tried valiantly to salvage the situation, but the momentum had shifted decisively. The judge, having already articulated the necessity of expert evidence, was not about to let the plaintiff's vague accusations stand on their own. The concept was straightforward. If you want to prove that a professional acted negligently, you must bring forward credible, qualified, and admissible expert evidence to show how and why that professional deviated from accepted standards. Without it, you might as well be pushing a boulder uphill. In the end, the ruling was swift. Our motion to dismiss was granted. My client was relieved. No costly, time-consuming trial, no lingering uncertainty. The plaintiff's inability to produce expert testimony had doomed their case from the start. For me, it was a small personal milestone. Though I was still relatively junior in my practice, I had just managed to secure a clean, elegant victory, one that underscored a fundamental principle of the law. There is beauty in such moments, when jurisprudence meets real-life timing so perfectly that it feels orchestrated, even though it is purely coincidental. Walking out of the courtroom that day, my shoulders felt lighter. I had learned another valuable lesson about the importance of preparation and the serendipity that sometimes arises in litigation. Judges can shape the fate of a case with a single remark, and if that remark happens to align with your argument before you've even made it, consider it a gift from the legal god. In this instance, that gift helped me secure a win that I could take back to my office with pride, adding one more successful chapter to the ongoing story of my legal career.